Good morning, Ways and Means. It is Friday. It is May 8th. Good morning. We are going to work on two bills before lunch. S-323 and S-198. We're going to start with S-323. There's Bradley Showman, who's going to join us at the table if you're ready. Yeah. Thank you. This bill left House Ag unanimously, I believe.
Good morning, Bradley Showman, Office Legislative Counsel. And I am sharing Senate Bill 323 on my screen. So this is a long bill. There's a lot of different sections, and so I can go over the whole bill very quickly, or I could just focus on the money sections or the sections that have to do with fees and things of the sort. It's the committee's preference.
I think section by section.
Okay, that's great.
Is great. And we'll dive into the ones that have fee impact.
Okay. So section number 1 is related to milk producers, and this section fixes a kind of error in the statute that about who can request a hearing related to a dispute about contracts for purchasing milk. And so that one's pretty straightforward. This program amends the farm to school programs section. And so it moves the farm to school program, which is a program that makes grants to help schools teach about agriculture and things of that sort. And so this section would permit the Agency of Agriculture that administers the program to provide grants or contracts to do this. And they wanted to do that for administrative ease purposes. It should not have an impact.
This is the perfect speed. Thank you.
Okay, thank you. And section number 3 is the pest control compact repeal. So there's a interstate pest control compact that we were part of. However, that compact was defunct in 2014 due to a change in the IRS tax status. It was still on our books, but has not been receiving money or funds from the state, and so we're taking it off the books. Section 4 is related to licensing, the licensing exam, or the licensing exam for certified applicators of pesticides. So this does have just a slight change. So what it's doing is it lets people take the pesticide exam any number of times as opposed to capping that at 3 per year. And it also removes the fee. We're on page 5, lines 10 and 11. It removes the fee for state governments, municipal or public education applicators exam for $30. So that fee has been taken out.
Let's pause for just a minor second. I would say I appreciate when we sort of charge fees from one place that will then need to be covered by another place. I feel like we're just shuffling papers and not getting revenues. That works for me.
Sections number 5 are seed law changes. So these are mostly conforming changes to seed law. You'll see just some typical grammatical changes. We are adding wildflower seeds to what is covered seed. So seed law has to deal with things like labeling, what's in seed, and requirements for selling and distributing them. And so we're making sure we're adding wildflower seeds to the flower section. And then we're also changing a labeling requirement here. And when I say we, I mean the Committee on Agriculture, so I apologize for that. And so the committee added a requirement for bulk seeds to have the same labeling requirement. So if you go into a store and you're scooping out a big bin full of seeds, it's going to have the same labeling requirement as if you bought that in a separate container. And then there's just changing some conforming language to the administrative penalties on the top of page 7. Based on my review of this, it does not change any kind of actual fee or anything. It just changes the language to make it a little clearer. We're consolidating VCAP within VEDA. So the Vermont Economic Development Agency, or VEDA, administers a program called the Vermont Agricultural Credit Program. And currently, under current law, the Vermont Agricultural Credit Program kind of exists in its own chapter separate from VITA. And VITA has made an effort to move a bunch of its programs from various titles to its own chapter. And that's what this does. And so it does not change the program in any substantive way. So you'll see a bunch of underlined text. It's all underlined because we're moving it from one place to another. The substantive changes, though, is that there is a corporation called the Vermont Agricultural Credit Corporation that currently administers the program. And how it's set up is you have VCAP, which is a program. You have the Vermont Agricultural Credit Corporation, which is like a step above that program, and then VITA, which is a step above the Agricultural Credit Corporation. And so it's essentially just removing that middle piece. And VITA already administers that corporation. It's just removing a step. And so this section it moves all of that information over. It removes specific authority that went to the Agricultural Credit Corporation, and VITA already has the powers to do the things the Agricultural Credit Corporation was doing. And then this gives the authority to dissolve that corporation pursuant to 11B VSA Chapter 14. And I'm going to scroll because there's there's some conforming changes for VITA in sections 11 and 12 and 13. Oh, there is one change here. And so this is a conforming change, but it's a different kind of conforming change. So on section 13, page 16, there is VITA administers the Vermont Jobs Fund. And within the fund, there at one point was a kind of a loan, a line of credit that the Vermont Agricultural Credit Program administered that was up to $100 million. The VITA informed us that they have not administered this program in quite some time. And so this program is effectively defunct. And because of that, the committee is taking that out of the statutes. Some more conforming changes on section 14 on page 7. Okay, hemp oversight. And so hemp oversight is moving. So hemp is an agricultural product. And because it's an agricultural product, hemp is, or up until this point, if this becomes law, it will not be anymore. Hemp is administered and regulated by the Agency on Agriculture. But if you know anything about hemp and cannabis, they are the same plants. The different farming techniques and different strengths of the THC, the chemical that has the intoxicating effects, different strengths and different levels of THC determines whether or not something is hemp versus whether it's cannabis. There's also different ways to farm hemp. And so farming hemp, you farm it a little bit differently. The plants it can only have a certain amount of THC in it. There's inspections and things that go into that.
We got some preview testimony last week, sometime recently.
Oh, great. And so long story short then, the oversight of hemp is moving from the Agency of Agriculture to the Cannabis Control Board for all of those reasons. And so a lot of the changes that you see here is the result of bringing the program over from Title VI to Title VII. And then there are changes in federal law that are changing what is hemp, right? And versus what is cannabis. So more hemp products might become cannabis products because of a change in federal law. And so the impetus for this is to give the Cannabis Control Board regulation over both so it can better determine what is hemp and what is cannabis. That is the very short version of a very complex problem. And so this section deals with that. It enables the Cannabis Control Board to make rules. And
GovOps also spent a bunch of time on this section of the bill.
They did. And so this section defines what hemp is versus cannabis. If anything, if it's not hemp, then it's cannabis. It gives the Cannabis Control Board authority to make rules about what is and is not hemp. processing facility, the health and sanitary conditions of those processing facilities, things of that sort. So it's a big rulemaking process. And this also on page 24, and we're looking at number 11. And so this is a rulemaking section. So the Cannabis Control Board is given authorization to define what is a craft processor. So it's a small business that with different needs and risks to exempt these craft processor licensees from the requirements of the subchapter that the board find unnecessary to protect public health, safety, and welfare. And then so on the very next line, the board will also, and this is permissive rulemaking, so it's not required rulemaking, but the board will also have the ability to waive or reduce licensing fees for craft processor applicants pursuant to rule or readily accessible policy. So it doesn't necessarily have to go through rulemaking to do that. They can make a policy to exempt some license fees for craft processor applicants. And then number 13, they can also, by rule, exempt certain product categories from the requirements to register under this chapter. So I'll go over the fees. The fees are a little bit later here, but there's some wiggle room to define who's exempt, some exemptions, and exempting products.
So I'm wondering, are there other things that like this in that don't go to rulemaking, but that could, I mean, what's the precedent for not going to rulemaking, and why do you think that's a good thing?
And so I wouldn't be able to explain the kind of rationale of how the committee voted and things of that sort, but I can explain that the permissive rulemaking on this section is to give the Cannabis Control Board flexibility to make rules if those rules are necessary. And so a lot of things are up in the air at the federal level with what is hemp and what is cannabis. And so currently at the federal level, there's a law that might go into effect, that will go into effect unless the federal government does something different. This law will go into effect on November 1st of 2026. That changes the definition of hemp from right now. And by changing that definition of hemp, if it does change, there's a class of hemp products that will now be considered cannabis. And because there's a class of hemp products that will now be considered cannabis, it creates some regulatory uncertainty for hemp growers and hemp processors who would kind of be caught up in this weird gray area. And so the impetus of this is to give the Cannabis Control Board some authority to kind of take it as it goes, because the committee won't necessarily be able to respond very quickly if nothing changes at the federal level. That said, there are some people who are optimistic. I shouldn't say optimistic. That would be their point of view. But there are some people who are saying that the likelihood of a change from the federal government about that more restricted definition of hemp might change. And so there is kind of just like this uncertainty. And because of that, there's a lot of permissive rulemaking in this piece. This piece is also brought over from very similar permissive rulemaking from the Agency of Agriculture. And so a lot of this section is copied from existing law that copies existing authority from the Agency of Agriculture to the Cannabis Control Board. And it's structured that way at the Agency of Agriculture too.
Thank you. And I would think that if how they're operating started to come out as something a concern, that the legislature could always say, well, we've decided you're going to go to.
I think that is exactly right. I mean, that would require legislative action. And so, they have to go through the whole process when the legislature reconvenes, but that is an option if something does say, I don't know about this, and change it later.
Sounds good.
Relative to that, I think the same thing on the page 24, line 14 and 15. When you're talking about waiver reduced licensing fees pursuant to a readily accessible policy, I'm just trying to understand what that policy is. And we've had conversations already about reviewing all the fees, making sure it's not necessarily delegated to an agency. So,
and so this bill, as written, would permit the agency to waive those fees without going through rulemaking. And And
What does accessible policy mean?
it might mean a memo posted on their website. It might mean, readily, accessible guidance, that you would ask them for, or that they would have some printed materials or something of that sort. It's not necessarily defined in statute the way rulemaking is.
Is it used anywhere else in statute, accessible policy?
I'm not 100% familiar, with other kinds of rulemaking on that piece. I wouldn't be able to give you examples at this time, unfortunately.
Thank you. A question from earlier in your testimony. You're talking about individual fees.
Oh, wait, sorry. I want to make sure that we're finishing this, like, this section of
This
it.
bill.
I know, this question of whether we're delegating authority on fees
Okay.
seems like very important. So I want to hold that question for a moment. Sorry.
And I understood why that's an issue too, so thank you very much.
Or do you want to comment on this from the sidelines?
Sure, for the record, James Pepper, Chair of the Cannabis Control Board. The direct answer to your question is yes, this is done in 7 VSA 911, which is a cannabis section around social equity applicants. This legislation is motivated by a number of hemp processors in the state that do not have a regulatory home currently. And they need some state agency to verify that they are not marijuana processors, they are hemp processors, even though they're dealing with cannabinoids. And sometimes those cannabinoids are above the federal threshold for hemp, but they're being converted into products that are below the threshold for hemp. So they need some state agency to verify that they are purely on the hemp side, not on the marijuana side. So a lot of this language was drafted before November, when we saw this dramatic change to the federal definition of hemp, but it had the 1-year delay. So what this is attempting to do is offer more flexibility to navigate what happens in November, because we may have what's considered a craft processor may be really small hemp processors, the sole proprietors that are making the full spectrum tinctures. It may be the kind of upstate elevators that have 30, 40 employees that are clearing $1 million in sales, $2 million. Because we just don't know if the very, very large hemp players are going to be able to sell into Vermont markets after November. So this is trying to accommodate the fact that uncertainty. And
So I think maybe, thank you.
Yeah.
I think maybe a great way that we can retain our authority and manage the uncertainty is to do what we did somewhere else recently, I don't remember where, which is you can do it in place for a year and then you need to bring it in for approval.
Can you say that again?
You can, you have authority in this interim period, but you need to bring it in for approval or for the next year. Yes.
Gives me, I don't disagree with what you're saying. But it's only to waive or reduce licensing fees. It's not to increase. So I think that,
You feel like it's okay?
yeah,
Yeah, I think
You also
so.
feel like it's
Yeah,
okay?
yeah.
Okay, cool. If everyone feels like it's okay.
yeah.
Okay.
Yeah. The fees will be established, whether or not they're waived or.
And I think it would be important, I do think that there are other agencies, and I have not seen the control board doing this. There are other agencies that have been waiving fees writ large for years and years and years without necessarily legislative eyes on that, which is like a whole other thing. So let's make sure before we finish this, that we have a way of checking back in, understanding when fees are being waived. It doesn't necessarily need to be approval. It could just be a report, but. Is there anything else in this section before I go to Representative Maslin's question?
Well, the current question first, and
Okay.
then, so I understood what you said and also what James said today and previously. It's a search for, within the context of the bill, search for a regulatory home during the interim period, which I think I understand between now and when the feds make up their mind, has started for the sarcasm. To clarify who can do what, basically, what the rules are going to be and when they're going to come forward. I'm not being the most articulate, but we have a gray period here when we're trying to figure out our way through this, and this bill is attempting to navigate that as concisely as possible, so we don't end up with our tail in the crack. Something like that.
Something like that.
Okay.
And so let me clarify just a piece. So nothing has changed about hemp in this moment in time.
Understood.
So a law will go into, if nothing else changes, everything stays the same, a law will go into effect on November 1st that does restrict what is defined as hemp. But there's also movement at the federal level to change that possibility.
That's what.
So right now,
Okay.
yeah, it's good in terms of certainty.
Thank you.
But it is about to become changed.
And that clarifies my question about the uncertainty, let's put it that way. Thank you very much.
Anything else on this section from, yes, yeah.
Yeah. So I did hear that there were early in the.
And let me tell you, no, it's his. I was surprised that
That's Rebecca's iPhone. Yep, there you go. She's got.
Okay, thanks.
So, you had mentioned, around social equity applicants. We going to be, and this is an agricultural thing. And there is some
We're getting a
pushback.
different cannabis bill.
Oh,
This is not the cannabis bill. We're going to get a cannabis bill.
Oh, so should I talk about that then? Because my concern is that there's, because you're talking about federal changes, is that there are federal changes around lives that could.
Let's talk about that when the cannabis bill comes.
Thank you.
Rebecca.
I just want to make sure we're done with this section before we get to your previous question. Is there anything else in this section you have not shown us?
This section does go on a little bit. I can come back to hemp. So if you meant the rulemaking section, no. If you meant hemp generally, yes.
Okay. Jim, seeds.
My backup question earlier on, you were talking about labeling of seeds.
Mhm.
How often does that come up? Wouldn't occur to me that that was a deal.
You know, I wouldn't be able to talk about how often it comes up. You know, I think when you're looking to enforcement of these kind of rules, it is a complaint-based policy. So some
Okay.
people will go to a seed store or hardware store and they'll notice that, you know, something is just like, what is this? You know,
Yeah.
and they can and will make complaints to the Secretary of Agriculture.
Complaint-based policy pretty much explains why we're where we are. Thank you.
Okay, back to the bill. Thank you.
And page 25, the Cannabis Control Board will have enforcement authority to test the products. And so this is part of creating that regulatory certainty. This is brought over from similar provisions from the Agency of Agriculture, but to test products to make sure it actually is hemp. And especially when there is that question mark about what is hemp and what is cannabis, because they are the same plant, it's just different strengths. Having that the Cannabis Control Board have authority to come in and test that, and it could order the destruction of a crop, it could order a stop sale order, things of that sort for things that don't meet the definition of hemp. Scrolling down on the 26, 27, the administrative penalties section. Under current law, the administrative penalties are defined under this section. They're not defined. They just permit the board to have administrative penalties to assess violations and things of that sort. There will be a different administrative penalty section that comes up for selling unregistered hemp and cannabis products in a moment. And we're on fees. And so the fee section here is quite a change from current law. Under current law, growers and processors. So we use the word producer for someone who grows hemp. And so that's just grower is producer in language here. So growers and processors, so someone who takes the plant and turns it into a product. The fees are changing quite a bit. Under current law, the fees could be much lower or much higher depending on your acreage and volume. And there is also a new fee for products. So each product will have to register annually for $75. So if you have different tinctures, different balms, salves, things of that sort, those products will have to pay a $75 fee to register annually. The board may issue longer registrations prorated at the same cost per year for products it deems low risk and shelf stable. So it doesn't necessarily have to re-register certain products every year, but it could prorate on a certain basis if it did a longer registration fee. Section 17 is a conforming change. It changes a citation because we're moving the statute. Section 18 is conforming change. It changes citation because we're moving a statute. And the Cannabis Regulation Fund. And Ted highlighted a problem for me in this section, so I'm going to go over that with the committee. So the control board is now taking on fees for hemp because they're taking over the regulatory certainty of that. And so we need to amend their special fund so they can receive that. And so this does that, except we made another change earlier this week that I'll go over in a moment. But basically, we are, so this underlying change does permit them to deposit the funds into their special fund for hemp. But we are also there is a provision here that issues fines and civil penalties for selling unregistered hemp products and unregistered cannabis products, which is going to go elsewhere in Chapter 31. And so, whether it's this committee or a different committee that amends this.
We'll need to amend that and then make sure we also have the reporting about any fee waivers.
Okay.
So I think we'll need to pick this up again on Tuesday.
Okay.
Amendments.
Okay.
I'm also realizing that there will be no time for tobacco today, dear people here sitting here waiting for tobacco conversations. So maybe we'll do tobacco on Tuesday.
All right,
Okay, I hope you had a really nice walk in the sunshine.
Really good conversation.
And maybe the healthcare committee will be happy forever that they get 6 weeks.
So that piece there,
near the room.
it is now moving to section 20 and the sales restriction. So on recommendation of government operations, the Committee on Agriculture added this section in. And so it's using this section, unregistered hemp or unregistered cannabis means products that are required by law to register that have not. And so if a person causes an unregistered hemp or unregistered cannabis to be purchased by mail or through a computer network, that is a violation. And it sets up the mental state, the intent, the knowing violation of a knowing or intentional violation of this section shall be punishable by imprisonment of not more than 5 years or a fine of not more than $5,000 or both. And then in addition to those criminal penalties, there could be a civil penalty of $5,000 for each violation. And so one thing that Ted flagged for me was that this civil violation piece, the Cannabis Control Board has authorization to deposit that into their special fund. Fines go to the state, the Committee on Agriculture didn't consider this piece specifically about whether that fine should also go to the Cannabis Control Board. So if it is not directed to the Cannabis Control Board, if there is a fine issued, it goes to the state under a different law in Title 13. Which is fine to leave it that way, but that's a policy choice that I'm now presenting to this committee. And if the committee wanted to amend that, it would amend that here. But I think this section needs to be amended anyway to enable the Cannabis Control Board to collect and deposit these funds into their special fund. With apologies.
Thanks.
And then the rest of the section goes into things that Attorney General might do. You might seek an injunction, and then any action brought pursuant to this section, the state will recover the cost of investigation, expert fees, and witnesses. And then a person who violates the section engages unfair and deceptive practices. And then all those profits, gains, gross receipts, and other benefits from the violation. So if a court determines that a person violated the provisions of the statute, anything that they gained from that is deposited into the general fund. And then that's that piece for hemp. So that is the end of the hemp piece. Okay. There's a provision here in section 21 on page 31 about the National Resource Conservation Council for mortgages. And so this is a curious little provision in the law, but basically the NRCC wanted to purchase some property, and there's some ambiguity in current law. It talks about them being able to borrow money, mortgage, and sell, and otherwise dispose of its property. And then there was a subsequent sentence saying that the real estate shall not be mortgaged. And it seemed to create some confusion about whether they could enter into a mortgage to purchase property. And so this provision takes that out, that sentence, to enable them to take out mortgages to purchase property.
Maybe we don't need to know it. Doesn't have to do it fake.
This section 22, page 32, talks about setting up a CAFO permit working group. And so this would be a working group of interested parties to make recommendations on the transition to the confined animal feeding operation permit required under Title 10. And so basically, it just there's now permitting requirements for certain farms for confined animal feeding operations, and so this work group would kind of study that and how to implement that, because that fine is new. So the membership of those committees, so 5 livestock farmers. Okay, great. And assistance from the Agency of Agriculture, meetings and things of that sort. There isn't the provision for money, so reimbursement of expenses in this piece. And then they can report or testify to the committee, so they don't have to do a written report. And then they define what's a farmer in good standing. Then this is a potential money piece here on section 23. The Secretary of Natural Resources, on or before March 1st of 2027, the Secretary of Natural Resources shall contract with a third-party consultant to help them with this. But there's not a specific appropriation in there for that piece. And then there's contingency funding for that section. So the duty to implement section 23, the confined animal feeding operation training on inspection. So hiring that consultant to train folks on inspection, train the state agencies on how to inspect farms to comply with this, is contingent upon an appropriation of funds for fiscal year 2027 from the general fund to the Agency of Natural Resources for those specific purposes. And then hemp oversight. Oh, I'm so sorry.
Going awfully fast, and I'm hoping we're gonna go over this all again.
We're not, so we can slow down. We're going slow on the fee parts, and we're gonna fly past the non-fee parts. But we're not gonna vote on it until Tuesday, because we have to make some amendments.
Okay, that's all.
And we can slow down in any section you want slowed.
I'm looking now at page 33, line 2. Who are in good standing. You said it describes what it is to be in good standing, but I only see what they're doing. The Champlain Valley Farm Coalition, the Watershed Alliance, and so forth. What does it mean to be in good standing?
That is a great question. And my apologies for kind of speeding over this.
You don't need to, I told you to.
And thank you. And so on page 35, there's a definition as used in this section, line 3. Definition of good standing means a farmer subject to the requirements of the subchapter and the requirements of chapter 215. So basically, folks that are not in violation of the required agricultural practices, they're following all the permits and requirements of the Agency of Agriculture, and they don't have active enforcement violations, that have reached a final order with the Secretary of Natural Resources and Secretary of Agriculture, and they're in compliance with any terms of any current grant agreement or contract with those agencies.
Okay, good. Good, thank you, excellent. Now, is this a good time for me to go back and ask a question about the fees, or should I hold off and wait till the end?
I think it might make sense to wait until Ted talks us through the fees.
Oh,
Does that make sense to you?
Yeah, sure.
Okay.
Thanks.
And that's all I have for the bill. The effective dates of hemp are on passage. There's still a big push for rulemaking, and so it's not necessarily flipping a switch, but it lets them get started on that more quickly. All their sections are on July 1st.
Yeah.
Jim, this isn't a question on fees, but now that we have Chair Pepper in the room, I'm just curious as to Cannabis Control Board taking over hemp. I know you have your own testing facility now. Any issues around cross-contamination or who would take precedence as far as testing, whether it's cannabis product or hemp product? Because the ag committee ag department used to do that on hemp, correct?
For the record, James Pepper, yes, that's correct, but they have canceled their program.
Okay.
So right now, no, like, if you're the bill actually leaves cultivation with the USDA. If you're putting your hands in the soil and growing hemp, you're licensed by the USDA. There's that one fee. It gives us just the authority to, if we see a field of what looks like marijuana and no one's registered with us, then it gives us the ability to go on and test. And you can see that the only authorization for the growers is testing. The products, we already have authority over. We don't have authority over the people making the products. And that's what this does. So we can already go in and compensate illegal hemp products and have to test it and compensate them for being sold at gas stations. But the processors are the ones that need that kind of state, seal of approval. They are actually hemp companies. And that's what this is doing.
Thanks.
Representative Brannigan brought up what the definition of good standing was. I think in other parts of, government incentive programs, it does say that they're also current on their taxes and that kind of stuff. Was that ever? I don't know that specifically in statute if it's required. I'm just trying to think about the definition of good standing means.
It's not necessarily required. I mean, it's something that could be, added in if they're up to date on their taxes and things of that sort.
So, when you were talking about low risk and shelf stable products receiving longer duration registrations prorated. So if it's a 5-year shelf life, then they pay that registration over 5 years. This is just probably ridiculous, but if they have the registered product, they pay that registration over 5 years, but it turns over quickly in the stores. That makes no difference.
I think that's potentially right. And so I think, if, that would be up to the Cannabis Control Board to kind of create regulation rules that make sense in that way. So 5 years might be a little too much for something, but a year and a half, 2 years, and it would be based on the product. And so, if there is a product that does have a very long shelf life or something of the sort, it might be based on that. So that is a possibility.
Okay. All right. Thanks.
About the criminal growing of hemp or cannabis. Perhaps Representative Higley remembers this, but years ago, I think 15 or 20 years ago, there was quite an issue over having hemp growing in the cornfields. And it turned out that was the bears. They would drag their food that they found in the woods, somewhere in the cornfield, where it fell onto the ground, the seeds, and it grew up with the corn. And farmers would be accused of trying to grow
Because it really is a weed.
Yeah, and an old one, came over in the colonial times. So where are we with that situation right now? Is that still a criminal act or not?
The laws have changed about the growing of cannabis, in particular. And so, people are permitted to cultivate cannabis. You have to be licensed to do that. And so if you don't have, I think Pepper was mentioning earlier, if they see a field that looks like cannabis, but they're not registered with them, they have the authority to kind of go out and inspect that. I'm not familiar with kind of someone alleging that they're accidentally growing hemp or cannabis or something of that sort.
It used to happen all the time.
It's interesting. And, and I imagine that is one of those things when an administrative agency issues a fine or a penalty, there are appeal rights under the Administrative Procedure Act. And so I imagine if someone were to get a fine or some kind of penalty, and if it's a criminal penalty or a violation or something of that sort, they would have the opportunity to explain themselves, whether that's an Administrative Procedure Act or a court proceeding.
So in current law, they would be assumed guilty until they plead their case.
No, no, no. I mean, an administrative agency has to take an action. And there is a presumption of innocence, especially in the criminal context, that the burden is on the agency taking the action to prove that that's sufficient to justify their fine.
These cases I'm thinking of would be, a lot of them, farmer didn't know what it was growing in the field. Troopers would drive by on a patrol, you know, just driving around the roads, see it growing in the field and investigate from there.
And they would,
This is a while ago.
yeah, enforcement officers would have the authority to investigate something that they think is a crime. And it is the burden of the enforcement authority to prove that a crime has been committed. Sometimes that crime requires knowledge of the fact or of the thing being done, but that's part of proving their case. And so, you know, an enforcement agency might see something, might see one plant and determine, you know, based on the existence of one plant that perhaps that's an accident or something and resolve it more informally. Or they might see several plants and want to investigate that further. But it is the burden of the enforcing agency to prove their case.
Seems harsher than it was.
And yet greatly out of our jurisdiction, so I'm gonna bring it to
Ah,
conversation.
okay.
Representative Brannigan.
Okay.
Representative Page, are you gonna make the bear and the woods joke or no?
No,
No, bear, okay.
No.
Okay.
I've already mentioned it to.
Good, I'm glad, I'm glad I'm not the
Express
only.
the-
Yeah.
And this may be out of our realm, but inquiring minds want to know.
They do indeed.
You mentioned product that exceeds its shelf life. How do you get rid of that product? How do you destroy it? Do you
Burn it.
Or I'm just curious.
Well, that is a good question. That is a good question. And so I think you dispose of a product the way you would dispose of any food type product that is past its shelf date by either composting it if it is something that is compostable or disposing of it in a landfill. And if it is like a drug, like a prescription drug or something of that sort, disposing of it in a way that's regulated by those agencies and regulated by the health department. So you don't necessarily want to flush your prescription drugs down the toilet, or throw them in a landfill. You want to dispose of them in an appropriate way. And so it's the same thing with cannabis products, hemp products. These are food, right? And so they're not regulated as food because they're also, cannabis is an unlawful product in interstate commerce. And so the Department of Health there's some kind of weird things with that. But it's food. And so we would dispose of these things the way food is disposed of. Food in terms of the sense of, an article for human consumption. So you're maybe not necessarily getting your daily caloric needs from these things, but it's for human consumption.
Thank you very much.
Thank you very much.
Thank you.
If you could work with Ted on an amendment, that would be great.
I will do that.
Barnett Joint Fiscal Office for the fiscal note on S 323 as it came out of House Agriculture. Relatively minimal fee or fiscal impacts here. First of all, anticipating very minimal positive impact from the changes to pesticide examination fees. From what I understand in talking with the Agency of Agriculture, the main problem there is because there's no fee assessed on the first taking for sitting of that examination, many people are just not showing up. So by including the fee on the first instance, so it's largely kind of shifting when people are paying in the timing of their examinations. I consulted with Chair Pepper, around the new fees for hemp producers, processors, and products. Given that under, how it would work with current law, as it is currently structured, the market for hemp products would be an intrastate market, so it would be limited to Vermont. The number of products would be, and processors would be accordingly limited. However, just want to flag for the committee, if the market was more, it was an interstate market, there are quite a few hemp products that would fall under this category. And so you would see quite a bit more revenue from particularly the product fee that is in the bill, and that could increase the estimate to approximately $90,000 in annual revenue if we're looking at more of an interstate market. But you want to emphasize that if things were to roll forward as they're currently structured, it would be more of a minimal revenue impact. The next piece is we don't forecast the impact of fines and penalties, but do want to note that the fine in the bill, the $5,000 fine, that would flow to the general fund, since it's not specified, minus a $12.50 court technology administrative fee that goes to the court technology special fund, and then the civil penalty is specifically called out in statute to go to the cannabis regulation fund. Again, we don't forecast the impact of changes to fines and penalties. You also wouldn't forecast the provision that would require the disgorgement of, unlawful revenue from selling hemp products to the general fund. The disgorgement part of the bill. Yes. I just had to say the word disgorgement. I was really trying to work that in there. Maybe it would just mean the money would be taken from those businesses and placed in the general fund. I also, for this provision, considered using the word scofflaw. That's fun too.
Oh.
Yes.
Like, in advance.
Of course, anytime. Finally, section 22, which creates the CAFO permit program working group, doesn't currently carry per diems, but as that moves to HAC, maybe they will consider adding those. And then noting the contingent appropriation for the contractor that would assist with the development of standards and policies around inspection of CAFO in those permits.
And at the very end of your sections 15 to 20, I think you mean, second to the last sentence, included a direct application of 2 million, not a direct app like there's a name.
That is the language that is referred to in the budget. It's a specific budget term for those funds. And so I should specify there is also, and I appreciate you highlighting this section, I kind of glossed over it because it is part of the fines, penalties, and collections. This would be if the Attorney General took a specific action against hemp processors. There's language that would allow them to recoup, essentially, so they would recover money from those businesses that were found to be violating those provisions of statute, and that revenue goes to a special fund within the Attorney General's office, and it stays in the special fund to pay for the budget of the Attorney General. A portion can be used to replenish the complex litigation special fund, which is used for contracted counsel, witnesses, more technical pieces of cases, and then also any additional money does get moved to the general fund through that direct act in the budget. And so in 951, as passed out of both bodies, that direct act was $2 million.
But that's not a reason, so it's just an explanation.
Yep, exactly.
The hemp going into the control board special fund, is that going to interfere in any way with the way all the money moves from there and how sometimes controversial that movement of money can be, or is that all? Okay.
No, in the current structure where the control board budget is built from the regulation fund and the balance comes from the general fund,
Okay, great.
elsewhere. Good.
Any other questions? Great, thank you. Oh, I kicked everyone out. Now we're,
No, no, we have time.
darn it. It's like the theme for the week. I'm glad we're ending on that note. It might be nice to just hear it from Jen and then not hear, then we can do all the other witnesses. Because Jen's hard to get sometimes. Thank you. Yeah, we'll take a quick